For pronouncement of judgment, WPC 412-424.
If petition allowed, order of the tribunal is set aside. However, if private respondents move a representation with a request to adjust them at Ajmer, the CBSE shall consider the same and pass appropriate order. And if
Obliged,
the
Lordship.
said post is not, is still vacant.
Obliged, Lordship.
For pronouncement of judgment, Writ Appeal 4 of 2020.
Writ petition dismissed.
List over. Adjournment request, if any, from item number 1 to 6. From item number 16 to 29.
With the consent of the other side, I beg to mention item number 19, my lord. May it be taken up on 23rd, my lord, 23rd of this month, my lord, if it is not inconvenient to your lordship.
So we have already heard the matter.
No, my lord, it is first time.
That is
listed
damages, that is. in
Damage
relation to
charges.
that.
This is another other matter, my lord.
This matter is regarding same.
Regarding damage charges, my lord, imposed by the railway. This has come up for the first time before your lordship.
So it's for the other side.
Lordship. I'm fine. Respondent.
Adjourn.
On 23rd, my lord.
Current contract which is like closed. They have raised.
Adjourn. Yes,
On 23rd, my lord. 23rd, my lord.
23rd.
Highly obliged, my lord. And my lord, item number 14 may be taken up by the other bench, my lord, since your
Item
lordship was a counselor in this.
40?
Item
14.
14,
40.
14.
14.
Yes, sir, not by me.
Okay. Another bench, one of which,
Obliged, my lord.
yes,
May I please your lordships, with the consent of the other side, I beg to mention item number 16. May kindly pass over the matter for the day, lordship.
you are for the
Appellant.
appeal.
Here, 40. One aspect of not considered issue of loss of when a bank employee loses the confidence, then switching to the thing first. Or we have right maybe listen to that. Because in that situation, the problem it is a lack of confidence.
Pass over for the day.
Not sure that's.
May I please, my lordship? With the consent of the other side, I beg to mention item number 17.
Yeah.
Can this matter be fixed after 2 weeks?
Yeah. 4 days. Every day.
You are for
I'm for the petition, my lordship.
this Guwahati University.
Yes, lordship.
This is a matter.
Yes, lordship.
You are, every time you are seeking adjournment, every time whenever it is listed, you are seeking
No, sir,
adjournment.
no, lordship, this is the another matter.
No.
This is the matter,
4 dates.
4 dates. A short adjournment.
Lordship, my senior counsel is out of station due to some personal difficulty.
A request for adjournment is made on behalf of the counsel for the appellant. It is noticed that on several occasions, the matter has been adjourned on one or other excuse. So, however, in the interest of justice, last opportunity is granted. List this matter after 3 weeks. Last opportunity, now argue it.
Much obliged, lordship.
May I please, your lordship? I beg to mention item number 41 with the consent of the other side.
41. Hearing matter. Adjourn
Any other request?
3 weeks.
Please, your lordship. My lords, with the consent of other side, I beg to mention item 28 of today's list.
28.
Yes, my lords, in this matter, the leading counsel's senior advocate, Mr. I. Chaudhary. If a matter listed before Itanagar permanent bench, he has to travel there. I pray that the matter may be adjourned for the day.
Finally, decision BJP.
After a week.
Much obliged.
May I please, your lordship? I beg to make a mention for item number 43 of the daily list. Lordship, the issue involved in this is subject matter is pending consideration before the apex court as well, your lordship. The matter may be adjourned till the decision is given by the.
43.
Yes, your lordship.
What's the matter?
Lordship, reversal of Senvet credit.
Person of Senate credit.
Yes, your lordship.
Adjourn. Yes,
Lordship, with the consent of the other side, I beg to mention item number 36, Lordship. In this matter, Lordship, we are filing our affidavit in reply, Lordship. Man is from Kanpur. He has sent the reply, Lordship. We'll file it, Lordship. I pray for accommodation for a week, Lordship,
10 days.
10 days. Obliged. Interim order as on today may continue.
Interim order, if I need to continue till next week.
Obliged.
May I please, your lordship? I beg to mention item number 33 and 42.
33 and.
42.
Where
I have
is
taken
Mr.
the
KL? You are appearing for?
petitioners.
Where is Mr. KL?
Mr. KL is coming from Dibrugarh today, so your lordship, can it be taken on next week?
43 and. No,
33 and 42.
33 and 42.
I have taken the consent from the other side.
Adjourn, adjourn.
Let's like to mention item number 44 on Lordship's daily list.
I will not be able to take.
But there's a new development in this matter. It's in this matter.
List before another bench, one of which. Whether a year ka one.
And
Yes,
the same matter.
Daily list for orders item 1.
Hello, in this matter, we have received a partial report. We'll be bringing that on record, Malak.
some partial report, but you were granted time.
Yes.
So
Yes,
Implementation of the.
implementation of that comprehensive scheme.
Yes,
but,
madam. What will happen, my lord, actually they are already in place. But since there's a
already
high court
in
order, my lord,
place,
we are
that
again
we have
going through.
on 13/5/2024, we have recorded there.
Yes,
But this, you were granted time.
we have
The
received,
guidelines are already in place. How are the status report regarding implementation?
my lord.
So I'll bring on record, my lord. So I have received a report.
Earlier also, you were on 13/5/2024,
Minus,
this
yeah,
action was granted. DK, Mr. D. Gogoi. I submitted the status report regarding implementation of the guidelines in book. Would be filed within a period of,
My lord, I can file it by 2 weeks, my lord.
within a period of 2 weeks, less after 2 weeks.
Oh, let me. Not something.
Item number 2.
Meet with your lordship. Lordship, we have received the affidavit filed by the department. My only prayer is, lordship, this affidavit was not something which we required. The court had asked for this affidavit. Our prayer.
We have asked to submit the details, the children who were admitted
Yes.
in the schools.
That affidavit
Lord-
we have filed, my lord.
We have the affidavit, lordship. Our prayers are very different, lordship. Our prayers.
What's your prayer?
Lordship, our
Your
prayers,
prayer
lordship.
was that the
Lordship,
court has already issued direction
Yes, lordship.
to grant admission to the children as per the section 12(1)(c) of the
Yes,
this,
lordship.
Education Act. And the state has come with the response that they are, the schools are granted admission to those persons.
Yes,
And what is the other relief?
Lordship, may kindly come to page 27, lordship. These were
27.
our primary prayers, lordship, that
27.
children, yes,
Just a-
lordship.
just a minute.
Our prayer number 3, lordship.
Yeah,
Prayer number 3 is issue directions to the state to create a management information system, lordship. Software in lines of part B of clause 7. If lordship will come to page 43. 43 of their OM, lordship.
issue regarding state to create a management. information.
Lordship, page 43. Lordship will kindly come to page 43. Serial 7, lordship.
43.
43. It is the OM issued by the Education Department.
Right.
Serial 7, lordship, may kindly come to the first. The school shall upload the details of admitted children in specific software by using their user ID and password, and a unique ID shall be generated for every admitted child, which shall remain the same during the stay of the child in the school. At the time of submission of school database, the school will submit the following school information. This is their OM, lordship. They have brought it in their OM, which was published on 2nd September 2021. But this has not been part of the whole process, which has started only after orders of this court. If I may just take lordship back for a minute, after filing 3 PILs, lordship, we have reached a stage today where the state has acknowledged 12(1)(c) as part of their duty, lordship. But even now, they are doing it just part-wise, lordship. We appreciate whatever has been done till today, lordship. But direction number 3 and 4, I pray before this court that they must comply with this, lordship.
Direction number 3,
Of my prayer, lordship,
your prayer.
page 27 and page 24. The fourth prayer is issue directions to the state respondents to create a centralized system through the means of a web portal or otherwise in lines of the SOP released by the National Commission for Protection of Child Rights, whereby children belonging to economically weaker sections and disadvantaged groups in the state of Assam who wish to seek admission in unaided schools and schools under the specified category can apply to the centralized system run and managed by the State Education Department and provide a help desk for filling of forms and officers of District Elementary Education Officer and officers of Block Elementary Education Officers in the state of Assam. These are the only 2 prayers now, lordship, which we are really pressing upon. And my prayer number 4, if lordship comes to page 80 of the objective of the SOP of the NCPCR, lordship,
Page number
80, 80, lordship. Lordship, this is the guidelines of the NCPCR, page 80, Roman 3, lordship, objective of the SOP. The SOP has been developed to provide a model framework to all the states UTs for effective implementation of Section 12(1)(c) of the RT Act 2009. It provides step-by-step guide to facilitate the state government in streamlining the system of admission and to ensure that children enjoy their right throughout the learning process after getting admission in the school. Since extending the fundamental rights to the children is the responsibility of the state, the procedures defined in this document are keeping in view the existing mechanism that could be utilized in the process. Whatever we have prayed for, Lordship, it is already there. The guidelines are there. They just need to adopt it or implement it, Lordship. The affidavit file, Lordship, it has given an idea of how many children have approached, how many have got admission. It would be better if it is in the form of a website, Lordship. Any person can apply and any person can check where the seats are available. It is only for the welfare of the children. There is no other agenda attached to it, Lordship. And few hearings back, it was said that they are already, a portal has been formed and they were supposed to show the portal to this court. We have an order, Lordship, where the learned counsel had submitted that the portal is under process and it would be implemented, Lordship.
They have. Order dated.
The portal is under considerations.
243. Right.
Where is it?
Yes, Mr. Majumdar? Yes.
No, the initial prayers that few students are not being admitted, they have been admitted, few students.
That they are already
Now,
appreciating that.
this portal part, it is before the cabinet.
Before the cabinet, what do you mean by before the cabinet? On 2/4/2024?
My lord.
You gave this assurance that we are going to, after the parliamentary elections are over, will certainly make it.
From the level of the government, my lord, that is at the level of the secretariat level, my lord, the portal has been, it has been approved by us. Now it has to come before the cabinet because, my lord, it involves,
If that is
it-
approved by you, then what the cabinet?
no, my lord, it will involve financial implications first of all. Secondly, my lord, since all the information of all the students and the parents of the students also, everything remains in this portal, whether it can be made accessible in that manner or not, what, how to implement this part
That,
is what is
the,
before the cabinet. That has to-
the SOP
My lord.
clarify all this, how to.
Well, that
create that
the
portal.
SOP says that it has to be accessible in all, but now Lordship will kindly
If that
appreciate.
is accessible in all, then it's
My lord,
accessible.
Lordship will kindly appreciate. This portal, when the student applies, he applies as an underprivileged student, or the parent applies as an underprivileged. That could be a case where he is suffering from a particular disease, which the law says that we cannot divulge in official records. It may be the economical or financial condition of the parent, which we may not be in a position to divulge and all that.
That is,
It has to get the.
those details are not required to be given at that portal.
My lord, in the portal,
Simply you have to give that these persons are admitted and these are
And the
vacancies there.
vacancy in the
Yes.
schools, Lordship.
That's all.
Lordship, what my friend is
That
submitting.
is what, those modalities, how to do and what to do has been placed before the cabinet for its approval, without which
That
Malad,
is
we
not
cannot.
required, that the status of the family under what category it is applied or
Malad, the
you simply have to
twelve
inform.
one C,
You simply have to inform
Madam.
that these are the seats vacant available or whatever it may be. So any interested person can apply for that. This is what the purpose of the portal is.
Malad, in the affidavit, we have already given at the district level the practical purpose of the act.
So whatever it may be, what modalities or whatever it may be, you ponder over it and this made available this portal to everyone.
Malad,
Whatever you want,
the underprivileged persons who actually apply, who can apply under this provision of the act are given all help at the district level by the district and the schools also. That is being done.
If
Every-
the SOP clarifies that these must be the portal, then what's the problem in that, sir?
Malad, SOP, we are not averse to the SOP. We are not averse to having a portal.
Then why
We
you
have
not-
done the part.
why created that portal?
But that portal being made open and
provides
what we call a
step-by-step
commissioning, Malad.
Guide, it provides step-by-step guide to facilitate the state government in streamlining the system of the admission
Yes.
and to ensure that the children enjoy their right throughout the learning process after getting admission, since extending the fundamental rights, children responsibility, the procedure defined in this document are keeping in view of the existing mechanism utilized for so and so. That is the mechanism they have already
We-
provided. You follow that
But
mechanism.
it is
Create
not
a
the-
portal.
it is not the case that these persons who are entitled to the benefits are not being given the benefits, madam. The affidavit which I filed will itself show that in some of the districts, the number of students who have applied, other number of students which have been admitted, and in other cases,
Lordship, this.
This-
Just a minute, madam, please, let him
Yes.
argue. I will ask you.
it's only a matter of time, my lord, before we
Just a
can
minute,
commission the
just a
portal.
Page 23, no?
Come to this page 84.
My lord. Page 84, yes, sir.
Now come to page 85.
85.
The online portal shall be generally accessible, especially provide to remote areas also and so as per the guidelines for the India so and so. And the online portal shall have the all necessary information regarding the admission 21C. They multiplied following information, but not limited.
Yes.
Now this, they have already given you the guideline.
These 1, 2, 3, 4 are already available in our department's website.
It's a department's website, you have to create a separate portal for that. That the SOP says, and this is this information we are required to.
The portal when
There is no question of disclosing the family background of the person, disabilities and nothing else.
most people kindly find.
You just read out all these 15, 14, there's 17 points they have mentioned. This information is required to given on that. And you are thinking we have to give certain information and that would be in, that is not there.
That is what
They have already,
the instructions that I have from the department is. Because at
another, they said the online portal
See,
should
portal
provide the
also,
real-time information on location and details of the so-and-so, class-wise number of the seats,
Yes.
class-wise number of the seat admission so-and-so, class-wise number of seats so-and-so, school-wise category, school-wise details and nothing else. Yes, they have already given, sir.
and this we could do, this could have been, okay, but the commissioning of the portal and all, it involves financial implication which has to
So,
come to the cabinet.
then say this financial implication,
There are
don't take
financial-
this
No,
excuse.
other-
that we
other-
are,
And the other part is there, other part is also there in the note.
So
But
that
it is
SOP is
ultimately-
already there. You can't take this excuse that we have to give this information and provide this information which is accessible to all and therefore you are facing some difficulty. There is no question of that.
That one part is the information part which we have asked the approval for, the other is the financial part. It is not that I'm trying to bifurcate the two.
Please,
These
you
are-
just tell us by what time you are going to this. launch this portal.
So she could have it next week, my lord. I'll have the written instructions on that. I can make a-
That is, sir, that is not acceptable. And ultimately, it's a, when the directions are already there,
No.
then why you are really delaying this? Every time you are coming with the excuse. And what about the other prayer?
Lordship, we have only these two pairs. One is the central. Lordship.
Software, this.
Yes, Lordship. And
Just
both-
a minute, madam, we are asking them.
Oh.
Please.
sorry, Lordship, I thought Lordship was
Yes.
asking me.
What about this?
What should we have it?
That your memorandum itself says,
Madam.
still you are not implementing that.
Then on prayers 3 and 4, Lordship will have it next week, my lord. I'll have my written instructions on that day. Give me something in writing.
That's okay.
Okay. And it counsel appearing for the petitioner has submitted that. So far as regarding the information provided by the state government in its latest affidavit, the prayer number 1 and 2 of the PIL petition has more or less been redressed. However, in respect of the prayer number 3 and 4, the state has not come out with a specific government that the creation of management, that the state has, that it has created a management information system slash software in lines with part B, clause 7 of the office memorandum dated 2021, and has also created a centralized system through a means of web portal in the lines of SOP released by the National Commission for Protection of Child Rights. And it concept for the state prays for 1 week time to place on record the status of creation of management information system slash software in the lines of office memorandum dated 2/9/21 and regarding creation of centralized system through a means of web portal in lines of SOP released by the NCPCR. List after a week.
Much obliged, Lordship.
Item 3,
May please the lordship.
7 and 8
Yes, it has been.
still not been served.
It's received back. AD in respect to something received back and the same thing is ratified again. But nobody has entered appearance. The amendment is on board. 21 each bill. Which one of that? The private school, private school, provincial school. But they are the main party. They are the ones who have taken over the school. These are state respondents.
Normally, who is appearing on behalf of the Tezpur municipal board?
Service was awaited perhaps.
No, no, service complete.
Service is
Then they
complete.
are not. None appears for them.
UIP.
I appear for the secondary education department.
As per the office report, notice upon the AD issued to the respondent number 1 and 4. 7 and 8 has been duly received. Stop having gone through the ADs. The service of notice upon the respondent number 7 and 8 is treated to be complete. List this matter for, list this PIL petition for admission after 2 weeks.
Your lordship,
May I
there
just
was,
point out one thing? my
there
lord?
was an interim order, your lordship.
Interim order. Interim order. If I need to continue till, what's the interim order?
Your lordship, that the administration won't act upon the letter issued by the municipal.
That is what I was trying to point out, my lord, in the
Action band karta. Letter.
Interim order to continue till next day.
in case the municipal board does not appear, my lord, the difficulty would be they have issued an order to use the playground of the school as a parking lot. So in their absence, if they have done it, if they've
If
used,
the notice is already served
yes.
and if they are not appearing.
If they're
please,
using that part as
what
a-
to do? We'll pass an order, ex parte. Can't help. It's not our,
provincialized.
once the notice is issued and served, and if nobody appears, what can we do?
This is a private,
Pass an order.
private,
Provincialized school, they are trying to use the playground as a,
it's a provincialized or a.
yes, provincialized school, they have passed orders.
That is.
Not-
it is
not with
open
our
for the
consent,
state.
not with
They are
our knowledge.
Willing to take any action. It is open for you to take any action against the authorities concerned who have granted this permission.
They being official authorities, we being another official authorities.
Sir, you are the state. How can you say you can't take any action against that? Yes,
Item 4,
No reply.
respondent number 40.
May I please? Your Lordship? As per my lord, previous order of the Honorable Court, my lord, service report is awaited, my lord.
Still in
My lord,
6,
as regards
14 and-
respondent number 6, 8, 14 and 18, lord.
When the notices were issued.
long back.
Lord, I took my lord fresh
Way back.
step on 3/6/2024. Lord.
Then again, once file fresh,
But fresh already I have taken, Lordship, I am paying my,
still that has not been served, sir.
my lord, kindly, my lord, this matter may be placed before the Wazma court to verify the service status, my lord. That would be better, my lord.
May I submit something, my lord? My lord, they cannot serve, my lord, because these are the president, my lord. Their term is already over.
These are the
there is-
president,
Yes, there are no president at this time, my lord.
president of what?
Gao
Gao
Panchayat.
Panchayat, my lord.
Their terms are already over, my lord, and we are going to election, my lord. Held the election.
What else then?
Because
Panchayat
allegation,
president, yes, certainly they can't be.
Yes, my lord.
but my lord, the allegation still remains, my lord, regarding, my lord, the misappropriation of public fund, my lord.
Secretary is involved. He's been served. The secretary, he's been served. That is why secretary also. He's a permanent person.
My lord, kindly, I may be allowed to take, my lord, notice.
You are appearing on behalf,
PNRD department, my
Huh?
lord. Panchayat department.
only Panchayat department.
Yes.
What about the other respondents, this respondent number 7, 9,
3, 5, 7, 9, 11, 13, 15, 17,
9, 11.
3, 5, 7, 9, 11, 13, 15, 17, 18. All of them.
3,
5, 7, 9, 11, 13, 15, 17, 19.
Secretaries are covered.
13, 15, 17, and 19. These are the secretaries of the Gram Panchayat whose presidents have also been made party. So we'll treat the service since the term of the president is over and this Panchayat is being represented through secretary. We'll treat. As per the office report, notice upon the respondent number 6, 8, 10, 12, 14, 16, and 18 has not been served till date. It is noticed that the above referred respondents are were the panchayat presidents of the respective panchayats, and their term has already expired. However, the secretaries of all the above referred panchayats are already represented by council so and so. Therefore, we deem it appropriate to waive the service of the respondent number 6, 8. Waive the service of notice upon respondent number 6, 8, 10, 12, 14, 16, and 18. This case for admission after 2 weeks. In the after 3 weeks. In the meantime, the respective respondents may file their response to the writ petition.
Not vacation.
Which vacation?
Puja vacation is coming.
3 weeks. If the vacation comes
Automatically,
in between, it will go again. Otherwise.
Apply.
Item 5,
Deep level.
Yes.
Your lordship, the the service,
1,300 days delay.
my lord, because of the pendency of the review petition, my lord.
Yeah.
Review was pending, my lord,
Review was pending.
my lord. The order impugn was passed on 12/5/2015, my lord. A review was filed on 28/6/15,
12/5.
2015, and review was filed on 28/6/15.
28.
6/2015, review was filed. Review got dismissed on 26/23, my lord. And this present writ appeal was filed on 15/9/23, my lord.
बाकी तो review. 15/5. वो 1 महीना में फाइल हो गया था. That was disposed of on 26/23. And this one 18, in 18/9 they have instituted the presence of 18. Main appeal. Here, the issue was whether the simple. So they have relied upon certain decisions of the central appellate tribunal. This would thereafter, no, this is not liable to be taxed. The order of the court here. So the original order is 15/5. But sorry, sir, 12/5. Sorry, he's right. 12/5. There was a mistake. 12/5. Original order, main order.
My lord,
petition.
it was passed on 12/5/2015, my lord.
Page.
Page.
Page 60 of the writ appeal, my lord.
Now.
Where is the review order?
Actually, it is at page 85, my lord.
Review of the engineering technicality. Around 9. Only one doubt. Potato to furniture. Even indirect. Won't that be? Okay. There is a private. I found that the value should include that. But that is just value should include that. When you take a cost, it means that it- what is the value? If only you recovery is settled with them, then they can wait to transfer it. But that aspect was not. This is the thing. This is the department has. The department has admitted that if value is cleared as waste and scrap, the manufacturer will have to pay an amount equal to expense nothing for the cost. But if they are liable, their amount is specific. This is not an expense liable, this is an indirect.
Yes, who is appearing for the,
I am appealing for respondent number 2.
what do you want to say? Respondent number 1, despite services not appear.
Oh, yes. Largely for 27 each. Deliver हुआ है.
The matter comes upon for consideration of the IA number so and so with the prayer to condone the delay of 2,300 days in filing the connected rate appeal. Stop learned concept for the appellant and submitted that the impugn or the learned single judge has ruled against the applicant's wide judgment dated 12/5/2015, wide order dated 12/5/2015 passed in WPC number 3165 public 2010. And being agreed with the same, the petitioner, the applicants have preferred a review petition on 28/6/2015, which came to be disposed of only on 20th of June 2023. And thereafter, the appellants, the applicants have preferred the connected writ appeal along with application for continuation of delay on 18/9,
15/9, ma'am.
15/9/2023. Learned counsel has therefore submitted that the delay in filing the connected appeal is bona fide because the review petition filed by it remain pending before the learned single judge for a quite considerable, for quite long time. But stop, it is further contended that on merits also, the applicants have a good case based on strong grounds and therefore in the facts, and therefore delay of 2,300 days may kindly be condoned. But stop. Notices have been issued to all the non-applicants the notices have been served upon all the non-applicants. However, no however, no reply opposing the application is filed on behalf of the respondent number 2, who is represented through counsel. You are appealing for respondent number 2, only 2, who is represented through counsel. And counsel, however, despite service of notice upon the non-applicant number 1, none is appearing on behalf of him. Taking into consideration the above facts and circumstances of the case, we are of the view that the applicants have satisfactorily explained the delay in filing the connected rate appeal. Hence, the IA is allowed. The delay of 2,300 days in filing the connected appeal is condoned. Registry is directed to register the connected appeal and list it before. It is already registered.
Written
No,
is
ma'am.
not there.
Register the connected appeal and list it before this court after 2 weeks for admission.
Deeply obliged, ma'am.
Sir,
This is the topic. So if it is application of tax, the tax burden is being shifted from the finance. That's the ground.
Deeply obliged, ma'am.
Item 6.
So this I cannot agree because I was there. I kept reporting. I can look at 6, my name is there. You
put
can.
up before another bench, which justice is not the.
Item 7.
This is again the information court of justice. By- Main, a conviction, main conviction.
May I have lordship?
ये वाला deposition order was किया था 1812 in liberty to file appropriate action before the district and council. He has finally done it. Then the other. Page 26, last line. 26. Paragraph. Internal page. वो नहीं हमारे ऑर्डर को देखो तो हमारे ऑर्डर को ये रिव्यू पिटिशन
Yes.
Lordship, we do respect Lordship. So, prayer is very simple, Lordship. So, here, Lordship, I may allow to only file a reference application before the Deputy Commissioner.
That
Lordship.
you already filed. That you already filed.
Lordship, initially representation was filed, Lordship.
See, you already filed on 8/3/2024.
Yes, Lordship.
Then you already filed that.
So my writ appeal was dismissed, Lordship. So
Writ appeal was dismissed.
yes, Lordship.
Yes.
If the Lordship writ appeal
What's the
dismissed,
ground for review?
review Lordship, here the impose the cost, Lordship, for the premature application, Lordship.
That London
cost-
Court of Judges imposed the cost,
Yes, Lordship.
and we observed that the cost is on lesser side.
So Lordship, that
Looking to the
70
age of
75 years old.
appellant, we have not announced that.
75 years old, Lordship, the cost amount, Lordship. If
Sir,
consider
again,
in
how
this
many
regard,
times you will approach this court for that purpose, sir?
Lordship,
Single
here-
judges impose the cost.
yes, I
You
admit.
approach the writ
Lordship.
appeal,
Yes, Lordship.
was dismissed. Now again review. What is the error apparent on the face of
So
the
there
report?
is nothing in error.
Nothing
error,
error,
Lordship.
then no case for review is made out, sir.
Lordship, we do respect, Lordship. So here, Lordship, so the reference case, I did not file before the Deputy Commissioner, Lordship. Only the revision was filed. So I may allow to, Lordship, a little bit
That,
modify, Lordship.
that liberty was already granted by the learned single judge in the earlier petition. That liberty was already there with you.
Yes, Lordship, but subsequently the writ appeal was dismissed, Lordship. So
So-
accordingly,
So that part has not been touched by the learned single judge while dismissing the writ petition. Earlier, the learned single judge granted you liberty to file
yes,
this
Lordship, I
reference
agree,
application.
Lordship.
You filed that.
ये तो फाइल किया है ये 2013 आई किया मतलब यहाँ पे तो कोई टाइम लिमिट दिया नहीं
Anything else?
Lordship, I have only one prayer, Lordship. So as because Lordship, the reference case I did not file, Lordship. So if Lordship, the little bit modified.
That liberty is already there, that has not been curtailed by anybody. That liberty is already there. You may file now if you have not filed already.
So that's why, Lordship, I'm praying for before the honorable court, Lordship, to file a fresh reference case before the court.
Sir, who is restraining you from filing that? Who is restraining you?
Yes,
Even in this order, we have not restrained you. The order which you are seeking to review,
yes,
we have not mentioned anything.
yes, Lordship, yes, Lordship.
Then,
Yes.
having heard the learned counsel for the petitioner, we don't find any case for review, and review petition is dismissed.
Master.
Item 8.
May I please? Yeah, no, so this incident matter pertains to non-compliance of honorable court's order dated uh, 3/5/2023, wherein
they were supposed
we have sought for the admissible allowances.
Yes, Lordship. So far as giving the allowance, so far grade 3 is, grade 4 was concerned, they were already getting. Now the finance has cleared. Now it is a matter of 1 month, 4 weeks. Within 1 week, Lordship, the judicial department will give the final proposal about the gettable amount, Lordship. And thereafter, in 2 weeks' time, we'll get it done, Lordship.
Have you filed any response on behalf of the respondent?
Earlier, we have filed, but this is the latest information. I have received the letter
So
today.
what was the latest information? We have, on the last occasion, you must have read. the
Yes,
order.
Lord.
What is this review?
Only
We are
issue
going to
was
file
lordship,
a
it is not
Review, what about that
No,
review?
review is still pending.
Still pending.
Review, in the review, the issue is lordship pension, which was not clear here also.
Whatever it may be.
Review is
Once the
pending. Now,
Review is pending, you may keep the review pending for how
No,
many
no.
years?
We are not waiting for review. Now the issue is here is that they should get the allowances which they are gettable. The review, it is regarding pension. Nobody has superannuated.
15, para number 15.
Para 15, it is directed that those of the appellants who have not been granted the benefit of allowance, even though they are drawing a minimum of pay scale, shall
As
be
a
afforded.
consequence, the appeal deserves to be accepted, impugned judgment hereby reversed as a consequence speaking order set aside. It is the appellants who have not been granted the benefit of even though they are drawing minimum shall also be afforded the allowance in accordance with the pay scale, the financial benefit accrued from the date of review of so and so. This is what you have to comply with.
Yes, Lordship, that is what we are complying now. In fact, so far as grade 4 is concerned, it was already complied. In the meantime, appeal was filed, SLP was filed by the finance department. It was dismissed. Now, we are now going to give all the allowances because the pension, that cause of action has not arises because they are all working. So the review, the pension part is remaining, Lordship.
Maybe, sir. You just filed an affidavit when you are going to implement this order. We have nothing to do, sir.
Lordship. Or if Lordship.
Granted. Mr. Sekia, please try to understand. If you are
That is
not
why I am
complying
appealing.
with the order on one or other excuse.
No, we are not. Now,
You are excuse, we are taking excuse and still you are.
Today I have received a final order from the department. Finance has already cleared it. The proposal which they have to now calculate about the latest entitlement, Lordship, that we are going to give. Absolutely, they will be getting it. We are complying it 100%.
Mr. D. Sekia, appearing on behalf of the London Advocate General, appearing on behalf of the respondents, has submitted that as a matter of fact, the benefit of allowances to the petitioner as directed by this court wide order dated 3rd of May 2023 shall be granted to the shall be granted, and for that purpose shall definitely be granted, and for that purpose the finance has already sanctioned granted sanction, and now the judicial department, which department is
Finance have cleared it, Lordship. The judicial department will give the final proposal about the
and now the judicial department has to give its final
proposal
regarding
the current entitlement, up to date current entitlement.
the current entitlement and the calculation of allowances which the petitioner is required to be paid. Full stop. He has submitted that a week's time be granted to file an affidavit of this effect on behalf of the
Let
respondent.
it be 2 weeks, Lordship. In the meantime, we will try to comply fully.
Sir, you please file an affidavit
Lordship.
within a week.
Yes.
Just after a week.
On the other hand, I just want to apprise this honorable court.
Sir, we want an affidavit of
Yes,
your
Lordship, we'll
part
wait.
that we
No,
are
no
going to
difficulty.
comply with it.
No difficulty at all.
It's all.
On the other hand, why we have filed a review? This honorable court did not direct it to pay pension.
Yeah.
We went to go to Supreme Court. Supreme Court added pension. And these are all contractual employees. That will have a big ramification, not
you
only
may-
in Assam,
that
pan
you may-
India.
That you may seek clarification or
Yes,
whatever it may be, otherwise you have to comply with the order.
Yes, Lord. Allowance is not a difficult proposal, but pension, Lordship, we have to.
Maybe.
It will crumble the whole economy.
In place of petitioner.
If all
petitioner,
contractual employees
there are,
getting pension.
Petitioners, not only one petitioner, in place of petitioner. Sorry. Yes.
Highly
Nine.
obliged, Lord.
Six and seven.
Six.
What the 6 and 7?
The still service is awaited, my lord.
Who are the 6 and 7?
They are the chairman and secretary of the cooperative society, my lord, Thalakura Cooperative Society.
You have to get them served, sir.
Can you?
You are not appearing, or you are appearing on behalf of whom?
Private respondent.
Await return of notices of respondent number 6 and 7 for. Yeah. लिखिए। देखिए notices issued to the respondent number 6 and 7 has not been served since long.
Well, 7 and 8, my lord.
7 and 8, 7 and 8 have not been served since long. 4 and 5. Full stop. Learned counsel for the appellant is directed to take fresh steps for service of notice upon the respondent number 7 and 8 through registered AD as well as Dusty within a period of 2-3 days. On taking such a step, as notice will be issued to the respondent number 7 and 8 returnable after 3 weeks. List after 3 weeks, interim order if any to continue till next week.
Item 10.
सर यहाँ पे 8 मिस्टर इस्लाम 8 7 budgets. In your cost title, have you filed an amended cost title? In the cost
No.
title page 2,
Only
it's
two
7.
respondent number 7 are there.
No, page
6.
2, page 2,
Page 2.
7, page 3, 7 and 8.
Page 3,
Page 2 is not there. Mistake.
That's the main appeal. Page 2, respondent number 7 last.
Hmm.
And the page 3, respondent number 8.
no,
In our copies, it has not come.
6 and 7. good. These are the. What's the name of the respondent number 7 in your?
But 7, the Halagora Assets Limited represented by its chairman.
8,
And 8?
8 is the secretary Halagora Assets Limited
No,
represented by
it is
its
not
chairman.
there.
it's not here.
It is not there.
That is why in the office note, it is 6 and 7.
6 and 7. no.
6 and 7 were in the writ petition, that is the page 3 and page 4.
Sir, here in this appeal, there is no respondent number 8.
8.
Lordship, may kindly see 2 and 3, page number 2 and 3.
2 and 3.
2 and 3 of?
Page number 3, 2 and 3 of writ appeal.
Hmm.
Page number 2 contains 1 to 7,
Hmm.
and
Then
page number
3.
3 contains 8.
But here in our copy, it's missing.
It's not there.
There is some, there is some.
6 and 7. Captain. This secretary has not been made.
Print out में रह गया. You take 7 होने से ही हो जाएगा फिर. 7.
7 good.
7. 7.
Not 6 and 7, only 7.
7. 6 is official.
Item 10.
My lord, may I pray that the matter may be passed over for time being, my lord?
Why it is listed for this orders?
My lord, on the last occasion, my lord, a notice was issued and we have taken dusty service upon the respondent number 3, my lord.
Yeah.
And they have entered appearance, my lord.
Subject to funding filing is to show for the
Service
name
is
of
complete, my lord.
on joint request. But why it is not listed for admission? Why it is listed for orders only?
Yes, my lord. It has to be listed for admission.
Has to be listed for admission. Is this case for admission? on, what's the date? 12th of September.
My lord, on the last occasion, my lord, my friend had submitted that they will not going to take any action after the debriefing meeting, my lord. So that's then may kindly be maintained, my lord.
Yes, we are maintaining that, my lord,
Yeah.
but we have some urgency in the matter, my lord.
That's why
Well,
we have listed.
And lordship may record was called for, my lord, record.
We'll consider it.
My lord.
And deeply obliged, lordship.
Item 11,
That's a bit common until beginning. Similar cases pending, yes, sir. 3 years residuary service. There is a delay of, for delays. Delay, 320, no, 320.
Yes, you are appearing for the respondent. In similar matters, we have already admitted delay after confirming the delay. Legal and concept of the applicant has submitted that in the identical, in the identical writ appeals wherein the impugned order passed by the learned single judge is under challenge has already been admitted while condoning the delay in filing those appeals. Full stop. And then council has therefore submitted that the delay in filing the connected appeal of 329 days be allowed. The delay be condoned and the IA be allowed. Learned concept for the respondent, sole respondent has no objection if the delay is condoned, hence the IA is allowed. The delay of 329 days in filing the connected appeal is condoned. Heard, is condoned. Appeal. The registry is directed to register the connected appeal and list it before this court after 1 week.
item 12,
This issue here.
May I please, your lordship? The service report is awaited in this matter. I am appearing for Esplanade 15, 16, 17 and 18.
On is await service report of respondent number 1 to 12.
12.
And how many notices the respondent has been deceived? Only in respect of respondent number 1? Or this is
They are the private.
as a 1 to 12?
1 to 12.
Respondents. The 13 onwards are official respondents, they are represented. So 1 to 12 notices were issued on, no, sir, 24/4/2020.
We take fresh steps for service of notice upon the respondent.
Your
number 1 to
lordship,
12.
you may allow me to take steps by dusting.
Okay, it is noticed that notices issued to the respondent number 1 to 12 are not being served since long. Let it be. Counsel for the applicant may take fresh steps for service of notice upon the respondent number 1 to 12 through registered post as well as AD within a period of 1 week. On taking such steps, let notices be issued to the respondent number 1 to 12, returnable 4 weeks thereafter.
Much of that.
item 13,
Same 3 years. Sir.
That's the registered AD as well as the.
Service on the same, full respondent is perhaps not complete matter.
Evidence.
That this is also same matter.
Same matter is the same.
Notice was issued on 2/8.
The delay is of 332 days.
Await return of notice of respondent number 1 for 3 more weeks.
Obliged.
item 15,
May it please your lordships, the application is for impleading the opposite party as a party respondent. The opposite party is a contractor, lordship, who has been.
What's the position? Now
It's
the
still not complete,
work
lordship.
is already completed.
No, no, lordship, it's not complete. The pillars are nearly complete, but then the flyover is still not done.
What it means? You mean to say that without issuing any tender and they have issued the
Yes,
work
lordship,
order?
they have started before the tender and then I have filed one tender along with the main PIL, and then later we have found that another tender subsequently was again issued. I have
You
filed it,
filed tender.
no lordship, I have filed it along with my PIL.
Yes.
But on behalf of the chief engineer, we have filed an affidavit. Now possibly they have filed an IF to implement someone. That I has
The agency which is constructing.
lordship. That IA copy, I don't have none. Otherwise, the IA for implement, it's up to lordship.
And what is the position, what they have said?
But they
That without even issuance of the tender, you have allowed the contractor to start.
But no, in fact, in paragraph 4, we have stated, the pursuant to a tender process, that was.
No, sir, date of tender and nothing else you have not produced on record.
But I have to get the record.
Okay, this IA is filed on behalf of the applicant with the prayer to implead the Anupam Nirman Private Limited as party respondent number 8. Party respondent number 8
Yes, sir.
in in this PIL petition. Let's stop para. This PIL is filed by the petitioner alleging that the construction of the flyover was the details of that flyover?
So construction of 4-lane flyover.
Construction of 4-lane flyover from Difu Stadium to head post office of Namding Dimapur Road, Difu in the district of Karbi along Assam has been awarded to the Anupam
Nirman Private Limited.
Anupam Nirman Private Limited without even calling for a tender. It is submitted that though the tender was issued inviting applications from the interested contractors, but prior to that, the Anupam Nirman Agents Private Limited was allowed to start the work of the above referred construction. Stop. Learned counsel for the applicant has therefore submitted that the Anupam Nirman Private Limited is necessary party to be included in the PIL petition. Stop. Having heard the learned counsel for the petitioner as well as the counsel for the state, we are of the view that the Anupam Nirman Agency is liable to be impleted, Nirman Private Limited is liable to be impleted as party respondent number 1 in the PIL petition number 38/2023. Hence, the application is allowed. The Anupam Nirman Private Limited is directed to be impleted as party respondent number 8 in the PIL petition number 38/2023. Amended cost title be filed by the counsel for the petitioner in the PIL number 38/2023, impleading the Anupam Nirman Private Limited as respondent number 8 within a period of 1 week. Filing the said amended cost title, let notice be issued to the respondent number 8 of PIL number 38/2023, returnable 6 weeks.
Much obliged.
For admission, item 18.
No, I checked those judgments, my lord. These judgments are not related to this kind of, my lord, land. This is a ancient, under section
You are well
19.
prepared with the order, but let us recapitulate. What was the order?
No, there is no order. Yes, my lord, page 10. Supreme Court order, flexi.
Yes.
Flexi, my lord.
But on that date, learned single judge, the brother Sham has said case some direction was issued.
No, some directions in some other cases relating to religious land. Religious land, my lord, some temple, etc., made, constructed in the, my lord, government land. So on that, my lord, this is not connected to it. This is an archaeological, this is a monument, my lord, which was, my lord, since 2013, it is in existence. section 19 of the, my lord, ancient
But,
monument.
Mr. Das, if some constructions are being raised
Yes. No, that. it should be-
outside the boundary of these monuments,
Yes.
and the persons were having rights over the land, how can we restrain
No,
them
no,
from?
page 41, your lordship can see.
Page
Not
41.
restraining, they will have to take action for, my lord, removal of those structures. And this is the duty bound to do that. Notice has been issued.
But if the persons are
Page
residing
41.
there, persons are residing there, then
No, they will have to take action, my lord. Otherwise, this is a, my lord, monument which was set up in the year 2013. And if even the government officers are also there. Government officers, they will have to do something, my lord. Page 19, your lordship,
What-
can
what-
41.
what we have gathered from this, whatever the photographs you have placed on record, sir.
Yes, photograph I have given, yes.
This 50, sorry, 50,
Yes,
51.
yes.
Now, this is the monument.
Monument, my lord, many such small monuments are there.
Monuments are there, and behind it, in page 50, the first photo,
Yes,
and the behind the boundary line, some constructions are there and some vehicles are also parking.
yes.
So if those persons are residing there since long, how can they be uprooted?
My lord, your lordship will kindly see page 41.
41. Yes.
This is a notice under section 19(1). They are bound to issue this notice and take steps. Your
It has
lordship,
come to the notice of the
It has
unauthorized
come to
modern
the-
artificial protected areas. Kachari ruins.
and
Has
it
been
is,
started, which is illegal, section 19, one of the so and so, so and so, so and so. So this is of 2019, but here the RCC structure, we don't find any RCC structure here, the tin shed and something there. The people are residing here.
The 40 May, page.
and now page 43, your lordship will kindly.
Yes.
44.
Department. Yeah, monuments. Mr. Das, page 40. Which is the monument here?
Monument, here there is no monument. These are all structures made by the sericulture department.
There is no monument.
There is no monument.
Then-
Within the boundary of the, my lord, protected area.
Where is that, sir? From where they get this?
Protected area, your lordship will get it in this 40. Page 44, your lordship will kindly see, this is a notification order issued to the settlement officer as apprised the deputy commissioner. With reference to the subject cited above, I herewith state that in the light of the report as submitted by the LR staff, dated so and so, has been existence Sa Mandir and so and so Mandir, pair of pond and incomplete house were the recorded. Further, it is also reported that an area of land measuring 102 bighas, so and so, pertaining to second RSS general khas dark number is recorded in Chita as Rajbari in remarks. Out of the above quantum of land and area of land measuring 40 bigha has been in occupation of the sericulture department of the government of Assam by way of planting shom tree and construction houses. It may be mentioned here that following are within the 100 meters of the boundary wall of Rajbari and another monument of Kachari ruins. Now, your lordship will kindly see section 19. Section 19, your lordship will kindly see.
या रास्ता के ऊपर में बना है वही maybe so there might be some.
Section 19, your lordship will tell me, a notice has to go for the first time. You have to respond. Miller.
Returnable also. So
Unless sericulture is represented by the government here, my lord, I can serve copies to them.
let them not say served. You get the notice served, so registered AD and this registered AD as well as this thing.
To all, my lord. Obliged.
The council for the petitioner may take step within a period of 1 week for service of notice upon the respondents to registered AD as well as the state. On taking such steps, let the notice will be issued, notice will be issued and made returnable 4 weeks thereafter.
Obliged.
Item 20.
May please, Lordship. My lord, here the respondent has filed their affidavit in opposition already. My lord, the dispute was contractual dispute and Learned Single Judge has given a direction to make payment within 60 days. We made payment.
You
But
made the payment.
we made payment because the time frame given. We made payment of rupees 49,93,235. Now, my lord, since the Learned Single Judge has interpreted the terms in some different way, and these terms have some chain effect where we follow the same terms throughout the country. The lordship may like to examine.
Learned Single Judge has taken into consideration that as per your committees or whatever the report.
No, my lord.
6.7 kilometer was the distance.
No, if a lordship kindly take, lordship kind, all right, my lord, lordship may come to page 129, I'll explain it. 129 is the committee report, the relevant part of the committee report. My lord, it starts from 128, I'll take your lordship to 129. My lord will kindly have a look. Number one, distance moved by empty trucks from Ramuddog private way bridge after taking tear weight to meet point of the railway station. This is empty truck. Distance moved from loaded trucks, meet point from the railway side to Ramuddog way bridge after taking gross weight. Distance moved loaded trucks from Ramuddog way bridge, Laipuli to way bridge, double payment, after then unloading. So we are only not giving 1.4, the first the empty trucks. The payment is made per metric ton per kilometer. If it is empty truck, there is no question of per metric ton, my lord. That is the dispute, my lord. We follow it throughout the.
So वो बात आके वेमेंट पॉइंट पे वेमेंट पॉइंट में रेलवे साइडिंग का है तो वो तो फेयरवे का नहीं है तो hearing.
This payment has already been made.
Yes, my lord. Payment is made.
This the net, let it.
Oh, lordship.
My lord, payment is made.
Admit. And so is appearing on behalf of the respondents. Service is therefore complete. All the respondents are represented.
Sole respondent.
Sole respondent. So is appearing on behalf of the sole respondent. Service is therefore completed. No need to issue notice. Hence, no need to issue formal notice. It is also to be as observed on 9/8/2024, the payment, the entire dues has already been paid to the sole respondent. No case for. You have not asked for interim order?
No.
Has already been paid. We made it clear that the said payment would remain subject to the outcome of this state appeal. Just in due course.
Item 21.
Need with your lordship. My lord, order of removal from service after disciplinary proceeding has been set aside by the honorable single judge against which I have come. My lord, the question falls for determination as to whether, my lord, that particular document at page 124, the honorable single judge has held that, my lord, there is a determined the discipline page 124, my lord.
Yes.
The honorable single judge has held that, my lord, by this, the disciplinary authority has already, while forwarding the inquiry report, the authority has already made up its mind. If your lordship finds, my lord, the allegations, there were as many as 6 allegations. And against that, my lord, while asking him to show cause, the disciplinary authority has also given a comment that the allegation is proved, the allegation is proved. Now, my lord, my humble submission with your lordship is that, my lord, this is a tentative, my lord, opinion. And on that basis, my lord, he was given the show cause.
How can it be a tentative opinion?
My lord, otherwise there is no question of, my lord, asking him to file a reply.
You can very well say the inquiry, as per the inquiry officer, this charges have been proved. You please submit your explanation. Disciplinary authorities comments, I agree with the views of the IA, allegation is proved. Where is the question of giving this?
But by this, my lord, he has been asked to show cause. If your lordship reads with reference to our letter number such and such, I forward here with a copy of the inquiry report on findings submitted by the inquiring authority along with my comments on the findings as stated below for your information. If you desire, you may submit your written representation submission within 7 days from the date of receipt of the inquiry finding. Please note that no extension. In the meantime, no like that. So, my lord, he filed a representation against that, my lord. It was considered a personal hearing was also given.
Where is that representation?
The representation of the petitioner. Oh, my lord, he appeared only for, my lord, the personal hearing. He did not give a representation. But personal hearing, he appeared. I'm sorry. So that is the only.
Paragraph 6 में यही नहीं पता paragraph 6 में कोई नहीं पता तो ये पॉइंट पे जाने ना जाएगी और फिर वो paragraph 6 एक so the document exhibit जो होता है the documented content was never proven. That thing.
Even you have not, no document, no witness was produced by the department.
No, my lord, witness
Who
is
has proved those? Where is that witnesses?
My lord, if your lordship kindly comes to the, my lord, report of the inquiry officer, that starts at, my lord, page 70, 70.
70, yeah.
70, my lord. This is the departmental inquiry report. Then page 71, your lordship will find presentation of prosecution documents. The prosecution submitted 90 documents bearing numbers so and so, so and so. Then your lordship may skip, my lord, and come to the
73.
one witness was examined, my lord.
Which witness, sir?
Page 70, 73, my lord.
So, Polita.
73.
My lord.
Prosecution witness, presence of prosecution number, Uttam Chandra.
Uttam Chandra Kolita, he was the, my lord, witness.
वही बोल रहे हैं नहीं किया
He had exhibited these documents.
लेकिन finding में भी he will produce it. And from the allegations, from the discussion of the inquiry officer, there is nothing. No.
He simply was named as a witness. Where is his deposition? And where is his cross-examination? Whether any opportunity was granted to cross-examine?
My lord, the copy of the day-to-day proceedings, of course, my lord, I have not.
Where is the deposition of that? You just show us.
No, that,
Somebody has to prove the contents of those documents. Who has proved those contents of the documents?
my lord, that will be in the day-to-day proceeding. I have to ask for that, my lord.
Submit this, and then only we'll consider 90 documents have been submitted. Who has proved those documents? Contents of those documents?
So that will be reflected in the day-to-day proceeding, my lord. That I have not annexed.
Nikhil, and concept of the appellant plays some time to satisfy this court that during the course of disciplinary departmental inquiry against the respondent, the department has produced a witness who has proved the contents of the documents on which the inquiry officer has relied, and an opportunity was granted to
Cross-examine.
the respondent to cross-examine the said witness. Just after 3 weeks.
Highly obliged.
Item 22.
Yes.
Lordship, actually petitioner needs some more time, Lordship. That's why petitioner
Petitioner?
needs more time, Lordship.
More time, the learned single judge is already granted.
Lordship, some more time, maybe even he is
How many
carrying.
more time, sir?
Lordship,
Sir, in fact-
other vacated, other petitioner vacated already, vacated the land, Lordship. Only this petitioner.
Sir, the learned single judge has already observed under such circumstances, this court is of the view railway authorities, para number 10.
Lordship, Lordship.
Within their liberty to invoke provision of so and so, so and so, if any such decision is taken by railway, the petitioner shall be put to notice within, within a notice today. In the alternative, the petitioner shall vacate these premises within 60 days from today. The court is of the view that period of 60 days is reasonable time to permit the writ appellant to relocate the railway land from the and alternate arrangement businesses, places, so and so. In terms of the above writ petition stand closed, the petitioner will positively vacate and hand over the premises which is on so and so.
That is the prayer. We, 8th May, we pray.
Oh, he prayed. Sir, now we can.
Lordship, may I pray one thing? Only notice may go and some time maybe allowed.
Sir, how much time?
Lordship,
30th of May 2024, the court has granted you time 1/8/2024. Have you vacated?
Lordship, petitioner not vacated.
You are
Except
not vacated
petitioner
still.
present appellant, Lordship.
Still after this 1/8/2024, 30 days, and now it's almost 39 days. You have already taken 39 days time, sir. You have not vacated it. This is a case, will positively vacate. There is a direction for you.
Lordship.
Having heard the learned concept of the appellant, and after going through the material available on record, we are of the view that the learned single judge has rightly refused to interfere in the proceedings initiated by the railways for by the railways against the appellant for vacation of the land occupied by him. It is to be noticed that the learned single judge has already granted 60 days time to the appellant to vacate the railway land from the passing of the order dated, passing of the impugned order. It is to be noticed that the other occupants of the railways who are similarly situated to the appellant has already vacated the land, vacated the railway land. Would stop. In such circumstances, we are of the view that the prayer of the appellant to grant him some more time to vacate the railway land is not justified on any count. Hence, the writ appeal is dismissed.
Like.
Item 23.
अब यहाँ पे देखिए जो गया था 33 सी में वो excessive without allowance, things that are entitled to 105 per day food allowance, increment on salary for the period of 28 years. He do money. Increment the vacation program from company and doing. What other things are earlier put, earlier directly, there was no such. So उन्होंने 23 into 8 और जो उन्होंने जो किया है सर 4 लाख समथिंग होते उन्होंने रिसीव किया फिर जाके ज्वाइन किया वहाँ वहाँ बोलते हैं कि बॉम्बे में मेरा कोई जो मुझे मारने को निकला ना था फिर सर वो जो एफआईआर आ रहा है वो 5 हो रहा है मुंबई हाईकोर्ट में तो सर क्या है Yes, Mr. Nath.
Today, the issue is, my lord, in 1990, when this workman was dismissed of service, his salary was 390 rupees. When he was reinstated, when that dismissal order set aside by the industrial tribunal in the year 2013, and in 2014, he was reinstated. So the tribunal's direction was reinstatement with full back wages. Now, in 1990, his wage was 390. In 2014, when he was reinstated, my lord. So for that entire period, the calculation was made on the basis of the 390 into 13.
23 into 8 months.
Yes, my lord. So as per the judgment passed in the government of India, my lord, the revision of pay, whatever will be there, my lord. They
Not work day for a day. Where is the question of revision of pay?
And their policy is individually assessed. And you are individually assessed by the company. Individual employees are assessed. And then the question of increment comes in. What is the error?
The error is, my lord. Suppose in 1990, if my salary was 19.
Come to para 11 of page 110.
Yes. The learned labor court, while passing the award, has made it clear that petitioner is entitled for reinstatement with full back wages from the date of dismissal. However, there is no specific direction as regards the notional increment to the petitioner. In the absence of such direction, the requirement of law is that the executive court cannot determine increment notionally. In such circumstances, petitioner is not entitled to increment. From the claim petition as well as evidence on record, the admitted position is that petitioner has already received an amount of 4 lakhs odd as back wages. Said back wages paid by management as follows. Page number 111, that 390 as it was in 1990, my lord. There's the calculation. Now, my lord, if your lordship kindly see the page 132 once. Page 132. Lordship has seen, my lord, this is exhibit 13 in the labor court, my lord, industrial court. Bottom, there is exhibit 13 marks.
Yes.
Now, kindly see, my lord, in 1989, that was the salary. So,
Exhibit 13 was disputed.
These are disputed, my lord. Now, if we other normal circumstances also, this honorable court, when the writ petition was going on, my lord, and that the two direction was given to the respondent authorities, my lord. You show us about the revision of pay took place from 1992 onwards, my lord. The honorable court has passed the order, my lord. Now, they are in the single bench, my lord. So they filed an affidavit saying that during that period, since he did not join, so couldn't assess it. But my answer is on that, my lord. You dismissed me in 1990. That was set aside. Now, unless you reinstate me properly, my lord, had they not been dismissed me illegally, my lord, I could have continued in the job. Now, there say there's no performance appraisal, my lord.
Very hypothetical.
Now, if I am out of the job, how can I perform my duties, my lord? And it is because of their mistake.
Performing, then how they?
You have also in your cross, it has come out that you had also not submitted any calculation sheet.
I have not submitted calculation sheet except the 13, my lord. But
13
otherwise also, lordship is
That
saying
is
there
a
are-
dispute. And you have, the learned single judge has noted that in your cross examination, you have admitted. Yes.
But also in the cross examination of the my lord, kindly see the respondent number, my lord, page 133, my lord. Please come to page 133.
Admit. Notice. To register daily requisites we filed within a period of 2 weeks. To register daily and so and so. Returnable 6 weeks thereafter.
My lord.
Nothing much is there, but it's okay.
But today I thought, my lord, at least for the issue of notice, my lord, I would satisfy and I'm pleased, my lord. At least let us in the hearing, my lord. Obliged, my lord.
Item 24.
So they are not Indian. अभी इन लोगों ने सर थोड़ा सा इसको चेंज किया petition का अपना और हदों लेकिन इन लोग अभी बोलना चाहते हैं बिजली अंदर पर बिजली उनकी नहीं जाना चाहते तो इनका एफिडेविट में अभी ये करेंगे पर गवर्नमेंट ऑफ इंडिया स्टैंड लेना चाहिए इनका स्टैंड है कि सर हमें 5,000 किलो दे रहे हैं या 500 हम दे रहे हैं तो इनको देना है तो गवर्नमेंट इनको ज्यादा कोटा देना है गवर्नमेंट बोल रहे हैं हमें एफिडेविट नहीं फाइल करेंगे
Yes.
May I please, Your Lordship? Lordship, we were supposed to file our affidavit. We have filed it on 21/6/2024, Your Lordship. And I don't know, the government is like.
We have asked for instruction on this, my lord. My lord, the matter relates to, my lord, it started during the COVID times, man.
Yeah.
For distribution of food grains to the
Underprivileged.
yes, my lord. Those in the Chakma areas, my lord. And although not being a producing state, my lord, Arunachal Pradesh, out of its the quota that it received from the central government, it has been distributing till date, my lord. Details are here. We have filed affidavit to them. Now it appears the petitioners are taking is stretching it to the level of grant of citizenship to the my lord, the Chakma people. My lord, that is always left to the Ministry of Home, my lord. The applications that we have received, my lord, from the Chakma community members, we have forwarded, my lord. So it is pending with them, my lord, and so far as
Here,
ration-
the issue regarding citizenship has never been raised in this page.
Yes, Your Lordship, we have not read that.
You simply said regarding this providing food,
ration cards, my lord, issue of ration cards.
that there is a ban.
Yes, ma'am.
Mr. Chaudhary, why don't you file any affidavit on behalf of the state, central government?
No, Lordship, in fact, it refers to only giving the food grains, Lordship, to the state of Arunachal Pradesh, as it has come up at that period of time, Lordship. And we had furnished the instructions, Lordship, it was given, Lordship. It is not a case that they are not receiving food grains.
Thing,
The
they are
central-
claiming issuance of ration cards.
Yes.
Ration card, Lordship, they will have to apply, they will have to go.
Yes, Your Lordship, we have applied.
They will
You have to apply in the, till your question regarding citizenship is decided, how the ration card can
That
be
is what-
given to you?
No,
Ration card can't be given to any person who is not a citizen of this country.
Your Lordship, we have, to that point, we have, everything has been replied in our affidavit, Your Lordship.
Yes, what is your reply? Even though if you are not citizen, you are entitled to have this ration card.
Your Lordship, as per the Supreme Court judgment, Your Lordship, wherein it was.
The Supreme Court said even though if a person is not citizen, issue him a ration card.
Your Lordship, here, Article 20, we can talk about Article 21, Your Lordship.
21, certainly, right
Yes.
to food is maybe a right to life also. So food, so far as regarding food is concerned, the state is obliged to provide you assistance on that part. But here you are claiming that the state be directed to issue ration cards to you and under the benefit under the various schemes.
Lordship, we have said only for those who are eligible and the person belonging to the marginalized section of the community, not
Indian
particular.
citizens, you
Yes.
mean to say that Indian citizens, where is that?
And so far as the Chakmas are concerned, Your Lordship, they are, as per the section 3 of the Citizenship Act,
There are many, Your Lordship, around 7,000 who are casting their vote. So they are citizen of India by birth, Your Lordship.
That way entire Chamlang district, 85 poor household who do not have the ration card, if your ration card.
Lordship, this matter,
Kadike will hear it.
yes, Your Lordship, this
Admit-
matter may be fixed for hearing.
Admit, no need to issue notices, parties are already presented, distant due courts.
Deeply obvious.
Fine. That's good. Yes.
Item 25.
My lord, in this case, today I have filed the reply to the.
Just now I have
affidavit.
received a copy. My lord, I pray some time, my lord. I may be allowed, my lord, 4 days time to file.
The learned single judge has already granted you liberty.
He has filed affidavit today, my lord. I have to.
That's
submit
right, but
reply.
in the learned single judge, I think so, what I still I remember that on the last occasion also, we have pointed out that the learned single judge has granted you the liberty, you have challenged that license which was already expired during the pendency of the petition. Then the learned single judge has granted that at the time of review, you may submit your objection, this renewal, you may subject.
PCB is interested with the private respondent, my lord. Our grievance is relating to issuance of certificates, non-agricultural land certificate that has not been reclassified
That's
as
why only the
non-agricultural land.
learned single judge has granted you the liberty at the time of
Yeah,
review,
well,
you
my
can
lord-
very well raise this
My
question.
lord, let me give that some time to file reply, my lord. I pray 4 weeks time, my
The
lord.
request of the learned council for the appellant this after 4 weeks.
Item 26.
Lordship may kindly take up the matter after some time.
Here they are to file the hydrological report.
Kindly,
Yes,
kindly take it up after some time. Lord.
No, what happened regarding that MOU with
The
the
MOU and the other developments, my lord, we are bringing it on record, my lord. We are filing the affidavit.
one petition is already pending before the single bench?
Correct. In fact, the PIL is first, then the petition came. We have objected that the petition by filing affidavit that similar cause of action is going on in the division.
Yes, sir.
The hydrological report is ordered by your lordship on 21st of June, that will be filed by them. Let them
Yes.
file and we'll give the, like, along with the affidavit, they let them file. If necessary, we'll counter it.
It is not the report, my lord, it is the MOU.
Yeah.
Not the hydrological report, my lord. Lordship has directed us to file the MOU. My lord. That we are.
You are in consultation with the IIT.
Yes, yes.
And for that purpose, you said, what about this, what development is that back?
My lord, everything we are bringing on record, my lord. We are filing the affidavit. We are filing the affidavit today, my lord. It is under process.
Okay, Mr. Dina has submitted that. The requisite affidavit would be filed in this matter during the course of the day. List after 2 weeks. Consider
After 2 weeks, my lord.
after 2 weeks.
Item 27.
May please, your lordship. Lordship issue is regarding regularization of 5th and 6th floor of the building. So we made an application before after the regularization of the 4th floor, we made an application before the Mayor in Council for regulation of consideration for regulation of fifth and sixth floor. That was disposed of by the order dated. It is order dated 2/9/2023. Wherein in the last para, it is observed, the Mayor in Council has observed, it is at page 49 of the read appeal. In view of the above, this appeal is disposed of with the observation that the authority in the GMC may regularize the extra floors subject to the meeting of the relevant criteria as required under Guwahati Building Construction Regulations Bylaws 2014 as mentioned, as amended up to date. So Lordship, this bylaw has the provisions for consideration of the regulation of the fifth and sixth floor if it comes within the compoundable FAR. Now, actually, the dispute was there was a plot of land, which total land is 4 kotha 10.96 lisa. And it is an undivided plot of land where my share is 1.5, 1 kotha and 5 lecha. Then another brother, one brother has raised the dispute, so dispute came. The building permission, initial building permission was granted on the basis of the 4.10.96, 4 kotha and 10.96 lesa. By considering the entire amount, FIR was calculated, and permission was granted. Now, one brother has raised dispute over granting of such permissions regarding his share. So, if that share is excluded in our humble submissions, two brothers, if the share of the other two brothers are considered, then it is within the compoundable FIR. And this, after this order of the Mayor in Council, the GMC has not considered in this line. Our appeal was not considered by considering the FIR.
One of the brother is not agreeable to, how can they include his land for the?
No, if his land is excluded, then also it will be within the compoundable FIR because the other two brothers, the other brother has also consented and they have submitted in my affidavit in reply, I have given one consent letter that's submitted by his brother and affidavit is there. Lordship. The other brother has who do not have any dispute because he has already constructed his building. So he do not have dispute. If these two lands are taken together, it is within the compoundable
What the
FIR.
learned single judge just said.
No, learned single judge has not considered that part because till that part, this is against the order of non-consideration of the interim order, and it was not considered on the basis on the strength of a judgment passed by the Honorable Apex Court in the Priyanka International.
Yes.
At that point of time, in 1998, this provision was not there. In the 1998 bylaw, this when it is within the compoundable FIR, that addition of extra floors to accommodate.
We granted time to the council for this Guwahati Municipal Corporation to file his affidavit.
They have filed their
that
affidavit.
these additional floors building will not come within the compoundable floor area as provided in the bylaws 2014.
Lordship.
Whether they have filed any affidavit?
They have filed an affidavit.
Where is that?
Lordship. It is there. What they have stated in their affidavit basically is before what they have done before the Mayor in Council's order. And Mayor in Council has taken into consideration the report submitted by the GMC at that point of time, and thereafter he has directed. He has observed, that was not a direction, but observation was there that if it comes within the compound FIR, after this Mayor in Council's order, nothing has been done by the GMC.
Come to this, their affidavit, na?
It starts from page 56.
Yes, come to page 59.
Appellant has constructed the building upon a plot of land measuring 1.5 lesa, 1 kotha and 5 lesa.
Yes. There is an existing road 8-meter width available in front of building as per 88 bylaw. Plot size is 670 meters. Maximum FR is permissible G+4. According to actual fifth floor building cannot be regularized.
Yes, that what they have done, this was done prior to the Mayor in Council's order. They have considered my share only.
Who is appearing for the Guwahati?
Now they are.
Who is appearing for the Guwahati Municipal Corporation? Have you filed any counter to this?
Yes, Lordship, I have filed.
What happened in the writ petition?
Lordship?
Writ petition, what happened in the writ petition?
Writ petition is still pending.
Sir, while this, filing this appeal, we can't grant this interim order, get regularize all these pending. Let the dispute be decided by the learned single judge.
Yes, Lordship, but we are only on the non-consideration of the this
Let
interim
the
order.
learned single judge be
Till
decided.
then, if the interim order is even, then
Interim order, sir, suppose interim.
because
order, okay.
what they have stated is the 1.5 kotha, one kotha and okay, 1 kotha and 5 lesser. But actually, it is now if the two brothers' land is considered, even excluding the disputed portion of the land, then also it comes to 3.5, 2 kotha and 10 lessers.
That you have taken this plea before the learned single judge.
Lordship, that stage has not come till.
Stage, why this stage at the time of this?
Lordship, this plea because this has come now only after the GMC
You
has
place
taken
it
the step.
before the learned single judge, he will consider it. You have not argued before the learned single judge what you are arguing here. And now we are saying that.
No, Lordship, what happened in this,
that is-
there was an interim
that
order,
is
so
absolutely-
non-consideration of the interim order, we came here.
Sir,
Now
you
the
can very
GMC
well-
has come to
you
a
can
different
very
standard,
well-
they have
You
given.
can very well approach the learned single judge with new facts, and the learned single judge will consider it, whether it's a case of interim order or not. Once you have not argued before the learned
This
single judge this point, how can we say that this order of the learned single judge is wrong?
No, learned single judge order was based on the Priyanka International case, and that time, that
Sir, what you are saying now that the
that we have argued.
if the land of two brothers is included, or then certainly that those fifth and sixth floor are compoundable.
Yes, Lordship.
You have raised this point before the land.
No, that was not, because this plea was not taken by the GMC. We are on the, because the entire permission was granted on the entire
It was
plot.
not taken, sir. The learned single judge has come to the conclusion.
Now only in the affidavit, they have taken this plea, the GMC.
And the learned say, as the construction floor of the sixth floor building without permission in view of the category was made by so and so. And this court is to consider the petition has not been a prima facie case for interim relief. Sir, you file another application, we can't do that. This can't be. Be careful. This writ appeal is filed by the appellant being agreed with the order dated 7/2/2024 passed by the learned single judge and writ petition number 560/2024, whereby the learned single judge has refused to grant any interim stay to the interim stay in the writ petition. Full stop. The appellant has filed the writ petition before the learned single judge, being aggrieved with the action of the GMC to direct the appellant to demolish the fifth and sixth floor of the building in question, as the same has been raised without necessary permission under the rules and bylaws. Full stop. Learned counsel to the appellant has submitted that, as a matter of fact, the fifth and sixth floor constructed by the appellant over the plot of land is liable to be regularized, is liable to be compoundable, as it very well comes within the compoundable floor area ratio in bracket FIR as provided under the Guwahati Building Construction Regulation Bylaws 2014. It is submitted that the two brothers of the appellant, whose plots are adjacent to the plot of the appellant where he has raised the construction, comma, is included with the plot of with the land of the appellant as per the Guwahati Building Construction Regulation Bylaws 2014, the fifth and sixth floor constructed by the appellant are liable to be regularized as per, regularized as the same comes within the compoundable floor area as provided under the bylaws of 2014. Stop. It is to be noticed that no such plea was taken by the appellant before the learned single judge or before the learned single judge at the time of arguing the writ petition on 7/2/2024. Stop. When the said plea has not even been raised by the appellant before the learned single judge, we don't find any illegality in the impugned order passed by the learned single judge. Hence, we don't find any force in this writ appeal. The same is therefore dismissed. However, it would be open for the appellant to file a plea which the counsel for the appellant has raised herein regarding inclusion of the plot of land of his brothers before the learned single judge by moving appropriate amendment application. By moving appropriate amendment application and then with moving an appropriate application with liberty to request for an interim stay during the pendency of the writ petition number 560/2024.
Item 29.
Yes.
Please, Your Lordship. Well, on the factual metrics that we submitted quite late towards the end of the settlement period, praying for extension. Well, to be fair enough, that was late.
That was?
That was late in the day. If you suffered so much, you would have submitted earlier. But that is, to be fair. But the writ appeal is on the premise. You know, that under the extent fishery rules, true, settlement has to be by way of tender system. There is no other way it can be done. But
day-to-day basis, there is no.
There's no, but there are two conflicting orders of this honorable court. By one order, in context with a particular fishery, with all respect, with context with a particular fishery, honorable single judge taking up that matter had opined and directed that if you cannot complete the settlement process by a particular date by tender, then do A, B, C, D, E to correctly settle for daily settlement. That my lord finds at page 34 and 36. Now, therein comes the conflict for which the division will happen. 34, I would invite my lord's attention to paragraph.
It is in respect of some other fishery.
Other fishery. Other fishery. The relevant paragraph is paragraph 16 and 17, which my lord finds at
46. May I read 16 and 17?
Yes.
It is further provided that in the event tender process cannot be completed within 10/5/2024, in that event, if ad hoc arrangement of daily settlement is made, the respondents, specifically the Commissioner and Secretary of the Government of Assam Fishery Department, shall, in respect of the present fishery in question, issue a guideline to be followed for having a daily settlement of the fishery in question. Thereafter, respondent numbers 1 and 2 shall also either have the Rule 12 of the Assam Fishery Rules amended or to issue a guideline for the entire state of Assam in respect of all the fisheries covered by the Assam Fishery Rules 953. This observation is made because this system of daily basis settlement of fisheries is coming in the way of timely settlement of fisheries by tender and at the time of multiplying litigation of this court. If for any compelling reasons daily settlement has to be extended beyond 10/5/2024, the process of putting the tender on daily basis shall be notified in the Dhubri district so as to enable all the fishery cooperative societies in the said area to participate in the process. Pausing for a moment, although it was fishery specific, but it has an effect pan-Assam, or an observation that you issue a guideline, this, that.
Whether the government is pondering over it to issue a guideline of this effect,
My lordships,
whether the government is ready to issue such guidelines or.
that is for the government to do, whether they come with review, comply, not comply, but the direction having been made, it's for bound and
Now, Action looking to the fact that model code of conduct was in operation, that was in that situation, some direction was issued. That doesn't mean with the suggestion, okay, you amend the rules and such.
with all humility, Miller,
In every
there cannot
case,
be a
we can't-
direction to
we can't
amend the
treat
rules.
it As a direction.
But so far as the correction of the thing, a direction to amend the rules, with all respect, that may not be there also. But regardless of the effect, I'm not an amendment of the rules. A procedure was thought, envisaged, and then
That was the learned single that is granted those directions looking to the fact that since the fishery can't be settled on account of this application of model code of conduct. In that situation, the learned single judge has issued a direction like, okay, continue with this fishery on with daily settlement. That can't be a rule.
there are two parts, Miller. Lordship takes up some things in between paragraph 16.
Yeah.
It says, thereafter, respondent numbers 1 and 2 shall also either have Rule 12 of the Assam Fishery Rules 1953 amended or to issue a guideline for the entire state of Assam in respect of all the fisheries covered by the Assam Fishery Rules 1953. So this is pan-Assam now. What I am on. I understand, Miller. We have been doing fishery cases. This observation is not in my way or against me. What I am on, the law be settled. That no direct settlement can be made, even for the, no stopgap
Even in
daily
the
basis can be made.
subsequent para, learned single judges observed this altogether different. In the event
70.
of trending process cannot be brought to his logical and conclusion, and from that there would be no daily settlement and fishery activity in the present ad hoc basis should come to an end, and the present fishery shall not be operated access as provided in this Rule 12 of
With
the
the-
Assam Fishery.
With the
This is the-
utmost humility, a cumulative reading of paragraph 16, 17, and 80 would reflect the mind in two ways. One, that in respect of a particular fishery, the guidelines are time bound, and the direction to the entire state is quite different.
The observation and directions contained in this order in interim nature shall not influence the final decision.
My lordship,
Everything is taken care
daily
of by the
settlement,
learned
so far as daily settlement is done, it cannot be done. That observation be there for any circumstances. What happens is one tender period would come to an end and the other starts, either the one continues or in his default, the other, there's no resettlement. There is some stopgap arrangements. If that observation follows.
It may, if we allow these type of.
No, not to be allowed, Miller.
Listen to us.
Lordship.
Then it may create such a situation that in any case where these officials are interested or in connivance with a person, they'll issue on this daily basis and whole this rules of 19, the scheme of rules of 19.
Correct.
the 53
Absolutely.
would, Go by.
But that is precisely what I'm praying, my lord. Let the position be clear that in no event whatsoever can there be any stopgap arrangement by way of daily basis.
That is there in
Absolutely.
the.
I bow down to you, Lord.
That is what the learned
Correct.
single judge has said.
But the conflict was there in view of this.
In fact, compliance of the learned single judge order, the order has been issued by the government, page 48, your lordship may kindly see.
48.
There are two orders, order dated 12/April 24 and order dated 7/5/2024. Page 48 first, my
Page 48, yes,
my lord.
order.
Yes, my
Hmm. And another order is
page, my lord, 50, my lord. 50.
Six is the impugned order.
Lordship, impugned order.
No, no, only this, you have mentioned this 48 and.
48
another
and 50, my lord. 50
50.
is another letter, my lord.
50.
My lord, 50. A specific format has been issued to all the deputy commissioners by the government of Assam Fishery Department to, my lord, submit whether any daily basis settlement is going on to stop all the daily basis arrangement.
Yes, Mr.
Yes, yes.
Now, what do you want? What relief he for?
But Lordship clarifies that there cannot be any way of daily settlement, stopgap in any circumstances
That the
whatsoever.
landed single judge is already
So,
observed.
we brought it to the division bench, honorable divisions, because the two orders were there, which could be understood
So
separately.
that order was
Lordship.
altogether different in the facts
Correct.
and circumstances of
Absolutely.
that case. That
The government understood otherwise.
Nowhere says that in case the daily settlement is allowed. It is nowhere said.
So far as the documents pointed out by my learned colleague Milord, the government also understood it with PANASA. So they took account of how many fisheries are there, daily settlement, what you are doing, don't, we have to submit report. They took it PANASA. They were not restricted by
No,
particular fishery.
Yes.
Lordship.
Tickets. Writ appeal is filed by.
And so far, my lord, this fishery is concerned, the process for regular settlement by way of tender has already been initiated.
Has already been
Initiated.
initiated.
Tender has not been issued, but process has been.
By writ appeal is filed by the appellant being agreed with the order dated 30th of May 2024, passed by the learned single judge in writ petition number 2816 of 2024, whereby the writ petition filed by the appellant has been dismissed by the learned single judge. Learned single judge. The appellant has approached the learned single judge with a prayer the appellant has approached the learned single judge stating that the Dimau Nadi fishery is settled, was settled in favor of him wide order dated 30th of May 2017 for a period of 7 years. And the period of said settlement is going to expire on 31st of May 2024. However, the respondents may be directed to extend the period of settlement since the appellant has suffered great loss in operating the fishery on account of COVID-19 pandemic and other instances. Full stop. It is contended that it is prayed before the learned single judge that the petitioner, the appellant be allowed to continue fishing in the fishery in question on daily basis after the expiry of period of settlement. Would stop. The learned single judge, having taken note of the rules of Assam, the provisions of Assam Fishery Rules 1953, particularly Rule 12 of the rules of 1953, has concluded that there is no provision under the rules of 1953 to settle a fishery on daily wage basis in favor of any person. The learned single judge has therefore rejected the said prayer, has refused to entertain the said plea raised by the appellant and has dismissed the writ petition. Would stop. Learned counsel for the appellant has fairly considered that as such, there is no provision under the rules of 1953 to settle a fishery on daily basis in favor of any person. However, he pointed out that in one of the another single bench of this court in writ petition number 1911/2024, wide order dated 9/4/2024, has issued a direction to the fishery department to settle a fishery in favor of the petitioner of that writ petition on daily basis till a particular period. It is submitted that the learned single judge in that writ petition has also the respondent has also advised the respondent state either to amend the Rule 12 of the Fishery Rules 1953 or to issue guideline for the entire state of Assam in respect of all the fisheries covered by the Assam Fishery Rules 1953. Full stop. Having gone through the impugned, having gone through the order passed by the learned single judge in writ petition number 1911/2024, we find that the said observations made by the learned single, said observations, public directions made by the learned single judge was in view of the fact that on account of operation of the model code of conduct, the fishery in question couldn't be settled by way of issuing tender, by way of issuing tender, and in that circumstances, the learned single judge has issued the said directions. However, taking a note of the said observations, directions given by the learned single judge in the learned single judge on 9/4/2024 in writ petition number 1911/2024, the state government has already issued order dated 12th of April 2024 and thereafter on this is another order, 4/5/2024, directing all the official concerns not to settle any fishery on daily basis in the state of Assam. Full stop. Having perused the order stated 12th of April 2024 and 4th of May 2024, we find that as per the directions issued by the state government pursuant to the order passed by this court, no fishery can be settled on daily wage basis, as no such provision of this effect is there in the rules of 1953. Full stop. Taking into consideration the above facts and circumstances of the case, we are of the view that the learned single judges rightly refuse to refuse to grant any relief to the appellant in the facts and circumstances of the said case. It is also informed that pursuant to the direction given by the learned single judge in the impugned judgment, the settlement process has already been initiated and applications have also been invited from the interested persons in relation to the fishery in question. Looking to the above facts and circumstances of the case, we find that no case or inference is made out and this writ appeal is dismissed.
Another interim order passed earlier shall be taken.
Yeah.
There was an interim order passed earlier, that shall be taken.
Interim order, the writ itself is now appeal is dismissed. How the interim order will continue?
That will automatically go.
Automatically.
Item 30,
My lord, a while back, we have received a copy of an affidavit, perhaps not on board, and we have also not gone through, my lord. Some other day.
Which matter?
Next matter, 30.
As a 30.
30. Just a while back, my lord.
Next week?
Next week.
Here, my name of SCFDC may be recorded. It is not recorded in the cause list.
Where?
In the cause list. SCFDC is not recorded.
Here in this item number 30?
30.
Item number 30. List after a week while showing, while repeating the name of so and so, so and so.
SCFDC.
Whatever, it may be you just realized. Okay.
item 31,
May I please allow, sir? Also, this petition is filed against the order of the Honorable Central Administrative Tribunal, Lordship.
Fail to maintain the using of the GP for general land. Then you were looking at
Did not dominate the balance of the prior to creating the indefinite.
Remained absent from duty on 12/12 and 18 and
Interim order is at page 171.
Madam, if we stay that order, that would result that you will continue with the inquiry. Then what remains that this OA filed by the applicant would be it would become infructuous.
That's it.
Then
Lordship, this memorandum of search has been stayed, Lordship, on the ground,
on the ground.
only on the ground that, Lordship, this
By the way, what are the charges against the incumbent?
his charges, his Lordship, he has participated in a strike. This-
कितने दिन के लिए?
Lordship.
How much days?
For
how many days?
3 days, Lordship. 3 days stays.
So
And as per the
that
conduct
is a severe misconduct.
Yes, Lordship, as per the conduct rules, Lordship, rule 23.
3 days if a person was
Conduct
and
rule,
even
Lordship,
remained absent from duty, that is from 12/12 to 15/12 without permission of the competent authority.
Lordship, as per rule 23, Lordship,
Explain it.
the employees are barred from participating in the strike. And for this, Lordship, disciplinary action can be taken against these employees. And also there is 2 other charges, Lordship.
And you have directed the wages of 3 days.
3 days, but it is barred by rule 23, Lordship. And also disciplinary in the memorandum of search has been issued, Lordship, and he has given the
Notice returnable 8 weeks.
Lordship. In the meantime, Lordship, the proceeding in the
Okay, interim. Still, we are not even entertaining this petition and you are seeking for interim.
Lordship.
Or argue it after lunch will decide it.
Yes, Lordship.
Will finally decide it?
Lordship.
Okay, okay. At 2. At 2.
Lordship. May I please, Lordship? Lordship, here the petition respondent is the Gramin Dak Sevak branch postmaster, Lordship. And he has participated in a strike, Lordship, and also called the other employees to participate in the strike. And on this ground and 2 others ground that he was unauthorized absent from duty, and another is he retained the excess amount instead of depositing it, Lordship. On these 3 grounds, he was a memo of search was issued. Page 14 is the memo of search, Lordship, and he was given the opportunity to participate in the inquiry proceeding, Lordship. But he has, on medical ground, he deferred participation in the inquiry proceeding. Thereafter, he approached the learned tribunal, Lordship. The tribunal on the ground that the balance of convenience is on his favor, Lordship. This interim order has been, the memo of search has been stayed. The only ground which the learned tribunal has taken that again, for participating in the strike, Lordship, some allowance has been deducted. This is time-related continuity allowance has been deducted, and on the same ground, this disciplinary proceeding cannot be initiated. But the fact is that, Lordship, as per the conduct rules 23, besides the deduction of TRCA and some other measures, Lordship, disciplinary proceeding can also be initiated against the employees. Lordship, the conduct rules has been submitted, Lordship. So Lordship, at this stage, Lordship, since the disciplinary proceeding is at the initial stage, and there is very limited scope of judicial review in the disciplinary proceeding, and without participating in the disciplinary proceeding, he could not, Lordship.
His principal ground is that since you have already imposed a penalty and deduction of salary has already been done, therefore, this initiation of disciplinary proceedings amounts to double jeopardy.
No, Lordship, Rule 23, Lordship, service conduct rule has been some.
Yeah, what it says?
As per the conduct rule 23, page, Lordship, page 27. It relates to strike.
Yes.
Married, Lordship. No sevak shall resort to or evade any form of strike, coercion or physical duress in connection with any matter pertaining to his or condition of engagement or the engagement of any other sevak. Period of strike shall be treated as under one, Lordship. The period of strike will not only result in deduction of TRCA for the period of absence during the strike, but also break in engagement on account of incitement, violation, and sabotage. This is one, Lordship. And thereafter, Lordship, and next page, some other measures are also there. The Roman 8, Lordship. The above action as per 1 to 7 may also be taken without prejudice to any disciplinary action that may be taken against such GDS.
Yes.
So Lordship, as per this rule, Lordship, disciplinary, besides disciplinary action, these other actions may also be taken.
Find a reply to the OA, place this ground before the land cat, they considered it and decided.
Otherwise, Lordship, the original application itself is premature one, because it is at the disciplinary proceeding is at the initial stage of issuing of memorandum of search. They have not participated, the respondent have not participated in the proceeding. Instead, he filed his Lordship OA. And there is also, Lordship, and Lordship, page 171, the interim order. Lordship, as per this interim order, since the TRCA has been deducted, so balance of convenience is in favor of the respondent in respect of this initiation of disciplinary proceeding. But Lordship, in order to have the balance of convenience, Lordship, there has to be some legal or fundamental rights in favor of the respondent. Lordship, since the initiation of the proceeding has not any adverse effect on his service condition or on any of his right, Lordship. So at this stage, the learned tribunal ought not to have, Lordship, interfered with this matter.
Okay.
And there is also, Lordship, two judgment has been.
What judgment? What judgment?
Lordship, first one is.
They have not set aside and quashed. They have simply passed an interim order.
Yes, Lordship, but against the interim order, Lordship, this judgment is of Honorable Supreme Court, Lordship, 1992 3 SCC 124. Union of India versus AN Saxena.
Yeah.
Yeah, this is para 6, Lordship.
Yeah.
Para 6, Lordship. May I read, Lordship?
In the first place, we cannot but confess our astonishment at the impugned order passed by the tribunal. In a case like this, the tribunal, we feel, should have been very careful before granting stay in the disciplinary proceeding at an interlocutory stage. The imputation made against the respondent were extremely serious, and the facts alleged, if proved, would have established misconduct and misbehavior. It is surprising that without even a counter being filed at an interim stage, the tribunal, without giving any reasons and without apparently considering whether the memorandum of charges deserved to be inquired into or not, granted a stay of disciplinary proceeding as it has done. If the disciplinary proceedings in such serious matters are stayed so lightly as the tribunal appears to have done, it would be extremely difficult to bring any wrongdoer to book. We have therefore no hesitation in setting aside the impugned order of the tribunal, and we direct that the disciplinary proceeding against the respondent in terms of the charge sheet dated so and so shall be proceeded with accordance with law. In fact, we would suggest that disciplinary proceedings would be proceeded with as early as possible and with utmost zeal.
Was in relation to an income tax officer who has passed
Yes,
the
that's it.
assessment order
Yes, yes.
in an irregular manner designed to confer undue benefit to the SSC concern.
But it is a
Was an income tax officer and
That's it.
the Supreme Court has observed in a case like this. So that depends upon its fact and circumstances.
And there is another lawsuit, 1994 3 SCC.
Yeah.
Here also para 6, Union of India versus Upendra Singh. Married lawsuit. In the case of charges framed in the disciplinary inquiry, the tribunal or court can interfere only if on the charges frame, rate with imputation or particulars of the charges, if any, no misconduct or other irregularity alleged.
Madam, so the still charges have not been interfered with. They have simply passed an interim order. They have not set aside the charges. How this is applicable in this matter?
Lordship, also.
This judgment is relevant when, if suppose the tribunal set aside the charges, then only.
Yes, Lordship.
Otherwise, it is not.
But in this case also, Lordship, there was no such condition to stay the proceeding, disciplinary proceeding
Condition,
at this stage.
discretionary
Lordship.
power, it can be done. Why should we explain? Yes. लिखा था. This writ petition is filed by the appellant, petitioner being agreed with the order dated 19/2/2024 passed by the Central Administrative Tribunal Guwahati in OA number 34/2024 preferred on behalf of the private respondent. Full stop. The private respondent has approached the tribunal challenging the charge sheet dated 18/12/2023 issued to it by the petitioner department. The tribunal, while issuing notices to the petitioners, have stayed the operation of the memorandum of the charge sheet dated 18/12/2023 till the next date fixed wide or impugned order dated 19/2/2024. Full stop. The tribunal has taken into consideration the arguments advanced on behalf of the private respondent that the principal allegation against the petitioner against the private respondent is that he has participated in the strike during period 12/12/2023 to 15/12/2023. It is considered that the as per the directorate in bracket SRN legal dated 22/12/2023, his TRCA, what is the full form of this TRCA?
Lordship, time-related continuity allowance.
Time-related.
Time-related continuity allowance.
Time-related continuity allowance
Lordship.
was already directed for the period the the private respondent remained absent from the due. Full stop. The tribunal has also taken into consideration that there was a charge of retaining excess cash of rupees 36511.90 against the private respondent, which was for the period when when he was on leave from 2/12/2023 to 11/12/2023. Full stop. The tribunal, while considering the said circumstances, the tribunal has also taken into consideration the another ground raised on behalf of the respondent that in case of the other employees, they have only issued minor penalty / charge sheet. And even in some cases, termination order was also withdrawn. Full stop. The tribunal, on considering the said arguments of the or raised on behalf of the private respondent, has issued notices to the petitioners and has stayed the operation of the memorandum of charge sheet dated 18/12/2023 till the next date. Full stop. Learned counsel for the appellant. The petitioners have argued that the tribunal has erred in staying the memorandum of the staying in memorandum of the charge sheet without there being any justifiable reasons. It is submitted that the inquiry is at the disciplinary inquiry against the private respondent is at the initial stage, and the tribunal has erred in staying the memorandum of charge sheet at initial stage. And it counsel has therefore submitted that the impugned order passed by the tribunal may kindly be set aside and the department be allowed to process the to proceed with the memorandum of charge sheet issued against the respondent. Having heard the learned counsel for the petitioner and after going through the material available on record, we are of the view that the tribunal has simply stayed the operation of the impugned memorandum of the charge sheet dated 18/12/2023 till the next date. Full stop. If the order passed by the tribunal is interfered with, then the same may result. Then the same may the same may result in then the department may continue with the disciplinary proceedings against the appellant, against the private respondent, and in that case, the OA filed by the appellant may have been infectious. Full stop. Otherwise, also looking to the charge sheet, we are of the looking to the charge sheet, it can be gathered that the principal charge against the petitioner of participating in a strike for 3 days and as such, 3 days and of retaining the cash with him for the period when he was on strike. There is the allegation regarding misappropriation, etc., is not leveled against the private respondent. Be that as it may, in the peculiar facts and circumstances of the case, we don't find any case for interference. However, it would be open for the petitioner to file their response to the OA before the tribunal, and if any such response is filed, it is expected that the tribunal shall consider the same and make every effort to dispose of the interim application preferred on behalf of the respondent along with the IA, or to dispose of the क्या लिखा है? Tribunal shall consider the request of the request, if any, made on behalf of the petitioners for vacation of the interim stay order, or to dispose of the OA filed on behalf of the respondent. Finally, at an early stage, at an early date. With these observations, writ petition is disposed of.
Item 32.
Hiding period may be fixed, lordship, for disposal of the OA, lordship.
OA?
For disposal of the OA, lordship.
लिखा है madam, that we have mentioned either the interim, vacation of the interim order or decision of the OA, final.
Lordship. Yeah, lordship.
May I please, your lordship, lordship, this writ petition is filed against an order passed by the learned CAT, lordship, yes.
Only consideration.
Lordship, I have seen that, but as it is, lordship, it is a case filed before my time. So I've seen the last paragraph of the learned tribunal, lordship.
They have simply said. we
Lordship, make
consider
an
it to be
observation.
Similar decision.
Lordship will make an observation and close the case, lordship. In fact, आता किंवा आहे नाही पाहिजे.
The private respondent has filed a OA before the CAT Guwahati with a prayer that the petitioners Union of India be directed to pay the license fee at the, to pay to the respondent the license fee at the rate of 10% compensation per month. That is from December 2008 to 2011, while he was posted at draftsman in the office of Commandant Headquarters 137 Works Engineer, CO 99 APO. Full stop. The tribunal, after considering the response filed on behalf of the petitioners in the OA filed on behalf of the private respondent, has issued a direction to the petitioners to consider the, where is that?
Page 51.
51. To consider the case of the private respondent with due verification, with a verification as to whether the private respondent is similarly situated with the other persons, wherein a direction was issued by this, the Guwahati High Court, white judgment dated 21/2/2023, affirmed by the Honorable Supreme Court, and if same benefit has to be extended to the private respondent, the same may be given to him within a period of 2 months. Full stop. We are of the view that since the tribunal has not issued any mandatory direction to the petitioners to pay, make the payment of license fee at the rate of 10% from the salary of the private respondent for a particular period, and only issued a direction to consider his case in the light of the decision of the Guwahati High Court. No case for interference is made out, hence this writ petition is dismissed.
Lordship, may kindly add, Lordship, consider the case with due verification, Lordship.
Due verification, thing. That is already there.
No, it's there in the, so like.
Due verification, without verification, how you will consider his case?
So,
Item 34 and 35.
Please, your lordship. My lord, my prayer is item 34 may not be taken up today, my lord. Maybe my planet.
34 be taken up today.
Not, may not be taken up today, my lord. It is appeal, my lord.
Without 34, how will proceed with this 35?
My lord, actually, in terms of the interim order, my salary has not been paid. My lord. So they're praying for some time.
They are praying.
No, this is my lord 30. I got to say 35. Here, 34, my lord. 35 is contempt application, my lord.
I think so. Last time you admitted that they are going
that's
to
true,
pay.
my lord.
Let both the matter come together, my lord.
No, my lord. But regarding my lord, contempt application, my lord. This morning, my lord, I have received instruction, my lord, that period, 28/4/2003 to 17/10/2003, disputed period is that, my lord. That period has been regularized, and sanction order has been passed for releasing her salary, my lord. So within 1 week, 10 days, my lord, it will be released, my lord.
That may be recorded and it can be closed, my lord. 2 weeks.
2 weeks. You file your whatever the complaints order, you may file by way of an additional affair.
This morning I have
consent
received
to the
the
parties list this matter after 2 weeks.
Different.
Item 37 to 40.
Huh? You file it, not today.
Not in this.
Yes.
Ahmed, please, Your Lordship. Your Lordship, this matters relates to four of the writ petitioners. We are assailing basically the ACE prescription that has been stipulated in the Assisted Reproductive Technology Act. Now, the government has filed its affidavit. They have brought out certain reasons, which in my humble submission, Your Lordship will consider. To my submission will be that these are not at all a rational justification. And another,
They are based on some expert opinion.
to my knowledge, no. They have all, if Your Lordship may just see one aspect. When the act bill was before the parliamentary committee assigned a reason for the ACE prescription based on the surrogatory bill. The surrogatory bill has not considered any medical opinion. They just prescribed the act, the age limit. Now coming to the reason assigned now, if Your Lordship may just see page 112 once of their affidavit. That affidavit is
Item number 37.
in item number 37. Therefore, and these reasons have been basically assigned after the Kerala High Court has questioned.
Page number 112.
Yes, Your Lordship, 112.
That starts from this one.
This annexure starts, Your Lordship, at page
106, Lordship.
106. But just Your Lordship may just see these are trailing emails. And at page 112, just above the date mentioned, 16 March 2023.
Yes.
Can someone aid about quality of sperms and other issues related to male fertility in males and with increasing issue? So what they are trying to say, they have prescribed an age, and thereafter, to find justification, they are calling opinions. There was never a discussion as to the pros and cons. You're restricting somebody's fundamental right of choice, fundamental right of a woman to have a reproduction, and you don't even go for a discussion, and then you come up with these reasons. These reasons are at page 117.
Yes, yes, page 117.
Your Lordship, first, I'll go to the issue of medical. I'll not go, I'll come to the issue of finance. There are two parts. One is financial, one is life
Not
expectancy.
financial, not financial.
There is bringing up a child at least up to 18 years to take care of the responsibility to provide care and financial support while the child is growing up needs parents with reasonable good health status and able to be financially stable.
Sir, general.
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 So I will not trouble your Lordship with that.
Fine.
Come to the last point. Women older than 50 deaths have a higher chances of chromosomal conditions such as Down syndrome and increased risks of pregnancy loss. Your Lordship, these are people who will be adult person at the age of say 49 for the female, for a male 54. Now, in all probability, in my case, is that through the normal course, they have not been able to conceive. Now, suppose with the help of IVF, they are able to conceive. They get another 13 weeks. If at all they conceive, they get another 13 weeks to decide. The the doctors will advise them that, look, your baby has, the fetus has a Down syndrome. 13 weeks, we know it can be medically terminated. What they are looking for is a hope that if it goes all through well, then why deprive them the risks on an assumption that their baby may be a Down syndrome? That can happen to a normal couple also.
So women older than 50 has
There is-
higher chances of high risk pregnancy in terms of increased risk of pregnancy induced hypertension, gestational, diabetes, cardiovascular complication, as well as the risk of preterm delivery and increased chances of cesarean delivery. These are the health hazard for the older pregnant women. First is this. Another is women older than 50 have higher chances of chromosomal conditions such as Down syndrome and increased risk of pregnancy loss. Third is all the more important. Every man's sperm quality is also compromised, is above 55 years old. The name of the mutations in father's genome increase that leads to an increase in the incidence of congenital malformation of offspring. Older parental age may be harmful to the offspring health in terms of genetic mutations and epigenetics. Sir, how can we ignore the rights of the child?
No,
Such are the risks.
No. Your Lordship will consider this from this perspective. With regard to the health, let's come to the sperm. 55. I had a talk with a medical lawyer. Unlike the age of woman's egg, an egg at the age of 40 or a 45 lady will be 45. Whereas for the sperm's age, what I've been informed is that sperms are all new after every 2 months. That is,
So there must be some material.
but Your Lordship, what I'll submit, Your Lordship, subject to what I'm seeking for is an opportunity to at least try. If my condition, if my doctor says that I cannot bear the child because of my cardiovascular problem or diabetes, hypertension, naturally they will have an informed decision to abort. What now I've been prevented is that only to get the chance also. If Down syndrome baby, I can abort it, Your Lordship.
What happened to the Gupta report is Supreme Court?
It's still pending.
Pending,
Lordship.
Lordship,
this is the main issue, Lordship.
But only problem is, Your Lordship, my age. Anyway, my hope is coming every day. All this problem with anyway.
We can't allow, in view of these, whatever it may be, we can't take a very, very light approach. We have to consider all these things in matter, particularly the rights of an unborn child.
The right of the unborn child is one aspect, Your Lordship. Right of
this, if he is suffering from any genetic this mutation, or malformation, that would be.
In 13 weeks, I get to know anyway, Your Lordship. In 13 weeks, I get to know.
The 13 weeks may not be possible. In 13 weeks, you may be able to know everything.
Chromosomal 22 weeks, I can.
नहीं बात। Let's hope that the Honorable Supreme Court may ponder over it and decides that finally. Otherwise, it's very difficult for us until and unless we have some concrete evidence before us that whatever the reasons they have mentioned are altogether superfluous or nothing.
Then Your Lordship, let's also hope that the Supreme Court decide. In the meantime, let the matter be kept there. I will also try to get some corroborative evidence to show this.
Subsequently, also the Honorable Single Judge's judgment of the Kerala High Court also stated by the Honorable Division Bench of the Kerala High Court also.
Yes.
No, Calcutta High Court also
Kerala-
has granted,
Kerala High
no, no,
Court.
Calcutta High Court Division Bench has allowed again. I am before Your Lordship. But I will try to satisfy Your Lordship. I will bring some material too.
The request of the Pankaj petitioner is this matter after 4 weeks.
What? 4 weeks ago, Not.
Supplementary list, item 46.
There was a mistake in her name in the petition. Instead of Maivangsa Malat, it has, it's up to the Hujai.
In the
Jointo Hujai, it has come up. Actually, her husband's name.
get it changed.
Maivangsa Malat.
Brother Nair is having some difficulty in taking up this. This the before one of us, not before one of us.
Item 47.
Wait, Vigilance. My Lord, this petitioner was appointed as a consultant for this particular work, my Lord. Now, his contract has been terminated. Now, as a matter of fact, the work has also given to some other party. Look, I am challenging his order from a different perspective. Now, what had happened, my Lord? Because the contract has been terminated, it entails some consequence. I cannot participate in any other contract. For example, if your lordships will kindly permit me, please come to my lord, page number 179. This is a tender issued by Madhya Pradesh Jal Nigam. Now, and the relevant portion is at page 184. Please come to clause 5.5. If proceedings for suspension or cancellation of registration or for blacklisting or for termination of a contract due to poor performance by the consultant has been started by the department undertaking of the government of Madhya Pradesh before the issue of the date of his RFP, and the same is subsisting on the last date of submission of bid, the bidder cannot participate in the. My lord, this sort of provisions are there in every contract. Yes. Now, my lord, my only submission is, my lord, though I am not challenging the termination of the contract from the point of view of permitting me to do the work.
Now that since another person has already been assigned.
Yes, so my only submission is, my lord, this should not come in the way of, my lord, subject to outcome of the case, my participation in other tenders. Because, my lord, end of the day, this blacklisting. My lord, basically, the ground on which the contract has been terminated is that I could not mobilize the key personnel. My lord, key personnel, I don't engage, my lord. It is NHIDCL they appoint me. And my lord, termination is not the only,
Certainly, sir, will consider it. that,
Yes.
This.
there is a
this
particular
part
process.
is order. So far as regarding this blanket order of this, that would be very difficult for us. Suppose he applied before the UP, state of Madhya Pradesh or any other. In this department itself, we can very well, after going through the, whatever
Can I
the,
say about
at this
NHIDCL? उससे होगा? नहीं, आप टेंडर कहाँ मारेंगे? 100% में कैसे interim order देगा?
anywhere he can, in any.
I got it.
That order from this.
At least NHIDCL lordships can protect us.
NHIDCL, if any order is there, we can consider it, or when we can do one thing, we'll hear it finally. Whenever you, which date you offer it, we'll hear it at admission stage.
Then, Milord, can I pray for Milord next Tuesday, coming next week, Tuesday or Thursday, Milord?
Which date?
Milord, August, September, आज कितना हो गया? 9th. Could it be on 17th, Milord? Is a Tuesday?
Then do one thing.
Or 19th?
No, have it in 19th, it can be.
Yes.
Then have it on 24th.
Okay.
24th. Madam, have you found
Lordship,
any counter?
Lordship, if your lordship may go kindly page 219, the honorable single judge has clearly stated, paragraph 9.
Consider it, madam, till deciding it finally on that day, we are not passing any interim order, that for that reason. On 24th, you be prepared if you want to file any counter, file counter or
The
otherwise.
counter is already there, Milord.
There is no requirement of that.
Oh, they have not
Consider
filed.
it.
First date what?
Counter we have not the first day, it was dismissed, lordship.
Issue
So counter we
notice.
could not file.
Issue notice. So and so
Thank you for my patience.
accept notice on behalf of the respondent.
2 and 3 I am appearing for.
Respondent 2 and 3, and Union of India is there?
Union of India is appearing.
Is the performer party?
No, performer party.
Performer, actually NHIDCL is the main
You are
part.
appearing for Union of India. Mr. So-and-so is appearing on behalf of the Union of India, and Ms. So-and-so is appearing on behalf of the respondent number 2 and 3. Service is therefore complete. Looking to the controversy involved and the urgency shown by Mr. K. N. Chaudhary, learned senior counsel appearing for the appellant. We list this matter on 24th of September 2024 for final disposal at admission stage.
Deep level.
Item 45, daily list.
May please your lordships. My lord, this matter pertains to settlement of fishery. My lord, an order at page 122 was challenged before the honorable single judge. If I may take your lordship to page 123.
100 and
122.
Second,
123.
My lord, can I pray for little accommodation in this case, my lord? Somehow it escaped, my lord. Only next week, any date, my lord.
My lord, I will not object to that.
any date.
Let it be on, my lord, 18th or 19th, 20th, any date, my lord. 18th, 19th.
19th, my lord. 19th.
19th. This one, 19th.
All right.
वो यहाँ पे कुछ